everybody has to understand somebody is going to take possession of your stuff. Don't think of it as planning for death. Think of it as planning for life. One of the advantages of trust is that there is this judicial supervision.
Can we talk about common mistakes that people make? Speaking of writing it down.
You can scroll it on a wall.
Welcome back to StreetSmarts MBA, the podcast where we teach you how to be an adult. Today we're talking about trusts, wills, and estate planning. Most people I know don't avoid this topic because they're irresponsible. They avoid it because they're not there yet, because it feels intimidating and overwhelming. This is not legal advice. This is simply a conversation. To break it all down, we have Gregory Dolin with us here today. Gregory, such an honor for you to finally join us.
Thank you. And so Greg is also fine. It's a pleasure to be here, and I'm very much looking forward to the conversation.
Wonderful. So if you would just give us a little background about who you are and why I insisted on having you with us here today.
So I'm a lawyer by training, although I don't really practice law regularly. I teach, as they say, they who can do and they who can't teach. So I teach. One of the areas that I teach is actually property law, which touches on trust and estates and wills. Because the question is often like, well, what happens to your property after you die? Or what happens to your property if you, like, who really owns it if you set up a trust? Like, who is responsible for the property and things like that. So I'm not really an expert in either trust or estates, which is why it's great as a conversation. We'll get the overview, but that's what I do. I've been teaching for longer than I care to admit. Since 2011, I've been full-time professor, and that's my area of expertise.
Great. So we'll dive right in. What I hear most of the time about this is when it comes to estate planning or wills is I'm too young or I don't have enough money. And this is for wealthy people. And meanwhile, most adults know they should have something in place. They just don't know where to start or what actually matters. So let's strip this down completely and start at the very beginning. If you had to explain this to a friend over coffee, how would you explain what a will actually is?
Or as I always tell my students when I ask them to explain a case to me and they start using very big legal words, I'm like, no. Imagine you're at your Thanksgiving table, you're sitting next to your non-lawyer uncle who's had a beer or two, you need to explain it to them.
Mm-hmm.
So, but let's begin with perhaps even before we even dive into that, let's begin with kind of just fundamental truth and fundamental kind of legal concepts. Number one, there's no such thing as property owned by no one. So somebody always owns it, right? So whether it's your house or the $20 in your wallet or, your old socks or whatever it is, somebody owns it. So it's either you, or if you pass, then whoever you leave it to by will, or if not by will, there are various laws that describe like whether they go to your spouse or your children or your grandchildren or whatever, or if none of that, it goes to the government. Back from the old like medieval days when I went to the crown. So when we're talking about, and the reason I begin with that is because when we are talking about estate planning, everybody has to understand it's somebody's going to take possession of your stuff. And the question really is, do you want to have a say in it? A, and B, to the extent you have people to leave it to, right? Obviously, some people, they never get married or they never have children, etc. And they really have no one to leave it to, and maybe they don't have enough to leave. And so they don't actually care that it goes to the state. But to the extent that you do care, or to the extent, or maybe you don't care, but to the extent you leave people behind, again, whether it's spouse, children, nephews, nieces, remember that by saying nothing, you're basically transferring work to them. They'll have to figure out what to do with everything from your socks to your house, to your like record collection, to whatever it is. So in some sense, kind of like, they say funerals are not for the dead, they're for the living. So too are the wills. They're not for people who pass on. They're really to make it easier for people who you leave behind, both potential to set them up financially if you have that kind of money, or even if not, then to make it easier for them to deal with already overwhelming thing when they have to deal with death as it is.
Well, how is that different from a trust?
So both trusts and wills are ways to plan estates. So will is simply a document that says, here's what I want to happen with my stuff, right? Like house goes to my, daughter, my car goes to my son, like my, bank account goes wherever, right? There are also certain rules about your spouses. So you can't actually disinherit your spouse. You can disinherit your kids generally in most states. But a spouse, depending on the state and depending on the length of marriage, usually, even if you leave him or her nothing in your will, usually will take somewhere between a third and a half of your total things. If you leave them something in the will, then they have a choice. They can take whatever you leave them, or they can take what's called their statutory share, between a third and a half of what you have. But so the will is basically a document that's actually formally called last will and testament. So that's your testamentary document saying, I want this to go to charity, this, and etc. A trust is not necessarily something that happens after death. A trust is what we call, it's a legal fiction. So you set up a entity, think of it like kind of a corporation, okay? And you transfer assets to that corporation, to that trust. And so, for example, you transfer, let's say, a bunch of stocks to the trust, right? And so now the owner of those stocks is not you, but the trustee. But the trust also has to have what's called the beneficiaries. So trust is set up for some purpose, right? You can set up trust to fund a college. You can set up trust to fund your children. You can set up trust to take care of animals or whatever, right? You can set up whatever purpose you want for that trust. And the trustee who technically owns the things in the trust, whether it's money or stocks or house or your farm or whatever, then they have to administer the trust in such a way as to benefit the beneficiary, right? So trustee is essentially just a manager. They get a fee for that, but they have a manager. Now, you can set up that trust while you live. You can set up the trust after you die. The advantage of setting up a trust now, there's some cost to it as well, because you have to pay the trustee, you have to pay to administer the trust, etc. But the advantage is that when you do a will, especially if you have a significant amount of money, will needs to go through a process called probate. So basically, once a person dies, we unseal the document. It says, okay, well, this goes here, that goes there. But a judge needs to make sure that the will was executed by somebody who was competent, somebody who was not pressured, nobody held a gun to their head, that there's no basically anything illegal, etc. And so before actually money or anything else gets distributed, it has to go through this probate process. And depending on the complexity of your will, it may take years. I think Marilyn Monroe's will was probated for something like 40 years because there was just complicated things because she had like intellectual property rights for movies, etc. So it can take a very, very long time. Usually not, but it can. Whereas a trust, because you leave everything to the trustee, it's called a pour over trust. Basically, in your will, you say all the money that I have goes into this trust that I set up before I died. You pour over all your assets, and then the trustee, it doesn't have to go through the probate, and then trustee then basically distributes it, whether it's interest or whatever else, in the interest of the people that you've named as beneficiaries. So the kind of the bottom line is that trust is a separate legal entity that actually owns the principal that you've put in there, and usually distributes interest and administers that principal in the interest of people you've named as beneficiaries. So you separate the legal ownership that goes to the trust and the benefit that goes to the beneficiaries. Think of it this way. Imagine you have a bank account, right? That interest-bearing bank account. Like traditionally, you can say, okay, well, I just want to take money out of that principal because it's my money, I can, etc. You can think of trust, again, it's not a perfect example, but think of trust as like you put the money in there, you can't actually take the principal. So the bank continues to own the principal, but they can't spend it. They have to invest it, etc., do with it and administer it to your benefit because you're the beneficiary. And then they'll pay you in some intervals the interest, right? And trust can last for a certain number of years after they, for example, depending on how the person who set it up directs it. After a certain number of years, then, like say after 50 years, then they can distribute the principal. But for example, one of the reasons to do it is that if you have, for example, underage kids, you don't want to leave them $1 million. They don't know what to do with it. They can't really, right? They don't have the life experience yet. Or even if they're already of age, but you may not want to leave like $1 million to an 18-year-old child, right? So you may want to set up a trust where basically it's a responsible party, usually some banker, etc., will administer the money and will pay to your child, necessary expenses. They'll pay for their rent, etc. But the child can't get the principal. And the principal can't really be spent on whatever the banker wants because the banker has a duty to administer that money in the child's interest.
Thank you for that clarification. Okay, so you have to have money to have a trust.
I mean, you don't, but obviously it's because you have to pay for the trustee, you have to pay to set it up, it stops being financially advantageous to have it, right? If you only have like, $1,000, the cost of actually setting this up and administering it is not going to be worth the can. So you don't have to, you can have a trust, you can set up a trust with $1. It's a question of, is it worth it? So, but obviously as you have more money and also as you want to the extent you care about making sure that after you die, the money is not quickly spent, that they go to like to the next generation, etc., then it starts making sense. But there's no requirement that the trusts have X number of dollars.
So, what does a will do that a trust doesn't?
So a will is no different than any other property transfer. So if you have a house today and you decide to sell it tomorrow, or
Hmm.
decide to gift it to your child or your spouse or your parent or whatever, once you do it, once you gift it, that's it. Like you have no more say, like nobody else has any say. Like, and if your child now wants to burn that house down, it's his house, they can do
Got it.
whatever they want. And a will basically that's the same thing after death. And so basically, once you've passed it, you may have very little control over what happens to it. There's ways to kind of ways around it because you can structure your gifts in a particular way. The gift basically gets canceled out of a child, or the basically donee does something that you disapprove of. But generally, that's what happens. Whereas a trust, because you don't give the principal to the beneficiary, you essentially protect the principal against wrong decisions. You make sure it lasts for a long time. And because you usually have to name a purpose for the trust, you can't just tell the trust, like, here's a bunch of money, go do good things, right? You have to say, here's a bunch of money, go do X, Y, and Z. It could be fairly generic. It could be said, take care of my child. But meaning they can't go out and then, take care of somebody else's child or donate money to, maybe a very worthy cause, like, I don't know, to save kids in Africa or something. Very important, worthy cause. But a trustee has to actually follow the purpose that the person who set up the trust directed. And it could be supervised by the court. So if the trustee kind of steps out of line, trustee will be responsible to the beneficiary, and the courts can supervise that. So the will dispose of your entire estate, and kind of that's it. Whereas a
Hmm.
trust allows what's kind of we sometimes call in legal world, it allows a bit of a dead hand control, right? You can say, look, this money can only go to this purpose. So that's kind of that's the other thing that trust does that will doesn't do is that you can set up a trust during your lifetime. So you don't have to wait until you die. Will only is operable at death. So which is why people can write a will and then can rewrite it and then can add things and they can subtract things. And when somebody anchors you, so like, I'm going to write you out of the will, right? You can do all of those things. And none of this really is operable until a person dies. Whereas a trust can be set up after death or during a lifetime. So if you want to put money into trust again for your kids or for your spouse or for your nieces or nephews or whatever, or for your favorite orchestra, right? You can put money there and you can say like, well, here's $1 million. I'm giving it to Chase Bank in trust for the benefit of Metropolitan Opera. You can do that during your lifetime. So potentially, depending on how you set it up, you can also have trusts that are revocable. Then, okay, I've changed my mind. Like I want all the money back. So you can revoke the trust. And then they're irrevocable trusts. And they have different, and this is really not my area of expertise, but I do know they have different tax treatment. So revocable trusts are treated one way in tax law, irrevocable trusts are treated differently. But the other reason to set up trusts is also different tax advantages, which I know nothing about. I know that they exist. I don't know how they actually work.
How expensive is it to set it up?
I think to set up is not that expensive. And nowadays with sort of AI and kind of in various like legal tools, it's probably as expensive as setting up a corporation. I actually recently helped my brother-in-law set up a corporation. Basically just like a few clicks online. I think the total like spent about I don't know, 45 minutes doing it. And the total cost was something like, I don't know, $200 or like $300. And that included both the fee you had to pay to the state to register the corporation and the fee for that AI service. So I imagine, again, I've never done setting up a trust, but I imagine it wouldn't be that much different. So I would imagine a couple $100. The question is not so much like setting it up, but the question is sort of administering it.
So the administering costs an additional amount.
Right. Because
Got it.
essentially what's happening, you're hiring a manager to manage whatever you put into that trust, right? And
Uh-huh.
the manager needs to get paid.
And that's usually done with a bank.
Not necessarily. You can have like, first of all, you can have more than one trustee. You can have your relatives. So, for example, you can set up a trust, say, for your child and say, to supervise it, who do I trust? Well, I trust my spouse. I trust my like older, like younger sibling. Maybe I trust my grandparent. The three of them will be trustee, and they have to. And that way, there's also some internal controls, right? So, like one person can't like make bad decisions. They have to all agree, or if majority of them have to agree. So you can do that. Sometimes, especially when big money is involved, people will set up what's called an institutional trustee, like a bank, a hedge fund, some sort of law firm maybe might be willing to do it because they have the expertise. They have kind of the also, if something goes wrong, they have the money to repay to the trust. So, but no, you don't have to set up a bank. You can literally pick anyone you want. Obviously, if you pick, for example, your spouse, you may have to pay much less for the management fees.
let's talk about single adults. If
Mhm.
someone is single, no kids, maybe renting, maybe working, what do people misunderstand about their need for planning?
To be honest, I think people mostly understand it. But I think, as you said in the beginning, you're right. People don't like talking about it because it kind of directly or indirectly involves talking about death, right? And nobody likes talking about that. And no, and especially as people are younger and as people who are younger and single, when they don't have the kind of the very obvious thing in front of their eyes that, look, I have this child that I need to think of in case something happens, right? It's in the back of their mind. So they may understand it, but it's just not a priority. But I think what people, again, don't understand is that when they pass, and of course, nobody can predict when that's going to happen, something will have to happen to their stuff. Everything. Like, if you're renting, you don't have a house to sell. But you may have your checking account. You may have some sort of investment portfolio. You may have your 401k. You may have like all of those things. You may have a life insurance policy.
Or student debt.
Student debt is actually, that's the good thing. Student debt generally gets forgiven upon death. So
Great.
at least federal student debt. So private one depends on the private lender, but at least federal student debt, that's kind of the good news. Your relatives won't have to deal with that. But yeah, so and then somebody will have to deal with this. So for example, when my grandfather passed away, he came to this country as an immigrant, like already retired. So he didn't have like he had like around $5,000 total. But he had a car and he had like and so we had to go through this thing. It wasn't luckily complicated for very small estates. Like I think usually, for example, in Illinois, I think it's under $50,000. You can essentially write an affidavit saying, yes, I am a child or grandchild and basically pay money to me and I'll be responsible for divvying up between everybody else. And you can do that. But it's still kind of work. And so what I think people don't understand is that somebody will be doing that work and you can make it easier for them or you can make it harder for them. And when you write a will or when you set up a trust, again, obviously, if you don't have enough assets, trust may not make sense. But if you don't sort of write it up, you create work for people who are left after you, and potentially you create acrimony. Because if you have, like, say, two siblings and both of them want something, right, and you didn't leave any instructions, you create acrimony between those two siblings. And that's also, like, again, maybe you don't care, like, once you're dead, but maybe you do, right? And so that's what people understand. It's kind of going back to what I said before. It's about the people who are left behind, not really about you.
So you have to be specific also in those cases because sometimes a parent would say, I leave everything to the oldest and let the
Right.
oldest deal with it.
Well, if they actually leave everything to the oldest can just like it's now theirs. Like they can choose to share or
Oh.
not. Or like, but actually that means they wrote a will. They've actually done something. So everything
Mhm.
goes to the oldest. But if they just simply said it at the dinner table and didn't actually write anything down, there's commercials on TV, so like it doesn't count, right? Like you got to actually do the document. And so now the oldest, the youngest, whatever, now they have to figure out how to divvy it up. Now, do you have to be specific? Yes, and it's to the extent that there are some things that are not easily divisible, right? You don't have to be, if you have like $1,000, you don't have to be, or $1 million, doesn't matter, right? Like you don't have to be specific, like, well, this $20 bill goes to that person or that $20 bill. It just says like, take my money, divide it into whatever halves or threes or whatever it is. You have to be specific which account goes to which person. But if you have particular items that are not fungible, right? Like if you have your grandmother's china, right, or something like family heirloom. And if you don't actually specify where it goes, then you might leave some acrimony to the people you leave behind because maybe more than one person wants it.
Okay, now let's talk about married couples. A lot of people assume that marriage automatically handles everything. And you said, well, it goes to the spouse. Is that right?
Well, if there's no will,
Uh-huh.
yes, then basically there are laws in every state that create basically rules of intestate succession. Intestate means without testament, so a
Hmm.
person who dies without a will. Generally speaking, and different states may have a different, but generally speaking, if a person dies intestate and is married, that means everything goes to the spouse because just simply because the way the law is written. So in that sense, people are right. The law does take care of all of that, but only takes care of all that to the extent that you don't care to leave anything directly to your children or maybe your siblings or your parents or whatever. So if you're basically okay with everything going to your spouse, then maybe you don't necessarily need to think about it. But there are also situations like what happens when, God forbid, like you die simultaneously, like say in a car crash. Then what happens? What happens when you die while, say, you're in the midst of a divorce or all these other things? Or what happens if you certainly want to take care of your spouse, but you also want to set up your children or your other significant people in your life. And without a will, without some sort of document, whether a will or a trust or whatever else, that doesn't happen. Everything goes to your surviving spouse if they survive you. So yes, in that sense, it's true. It takes care of it, but it takes care of it in very specific way that nobody except your spouse gets it, and only assume that your spouse actually survives you.
And if you're a single parent without a will, it doesn't automatically go to your children?
It does. The state laws have rules
Okay, so
saying that like
that rule is in place.
yeah, so like it has order of succession, kind of like
Got it.
spouse if there's a spouse, if not, like then children usually equally. If there's no children, depending on the state, sometimes it goes to parents, sometimes the next one is siblings. Then if not, then so it goes. But eventually you might run out, or there might be two distant relatives, etc., and maybe hard to find them. And again, at that point you have no say. So for example, if you want your kids to have equal things, fine. But maybe you don't. Maybe because one of your kids is, I don't know, like for example, disabled. And so you want to leave more money to that kid because they can't earn as much as other kids. If you don't actually write it out, the law treats everybody the same. So whether they're able, disabled, whether they're millionaires themselves, everybody gets equal share. All of this is basically can be thought of as under big rubric estate planning. And by the way, you can have both a will and a trust, right? You can have, say, look, you can say, for example, set up a trust during your life saying this is going to be to benefit whatever you want to benefit, and then also have a will. You can have a will saying, here's a bunch of money that goes to my kids, my spouse, etc. But hey, remember that trust I set up like 10 years ago? Some of the money is going to also go into the trust. You can set up all the money. So and depending on your tax situation, depending on your wealth, depending on your family situations, whether or not you need to take care of someone because somebody is, God forbid, disabled, or somebody maybe doesn't need to be taken care of because they themselves won a lottery or whatever, you can, have more reliance on a will, more reliance on a trust, etc. And as more complex your estate gets, the more legal advice you probably should get. And there are people who spend their entire lives actually devising way to deal with your estate.
And you said all of these things, the will and the trust, they can be contested after the death as well?
Wills can be. Trust really much less so, because trust is, especially if you set it up during your life,
Yes.
right? Then people generally can't contest that. People can contest things that, you leave behind after your death because people can say that you were not in your right mind, you were on drugs, you were under undue influence of someone. For example, like a classic example that I had to learn for the bar is, imagine a will document that says, and also I leave a bunch of money to my lawyer who, by the way, wrote this will. Now, it's not illegal to do it. It's not even unethical for the lawyers to take it, because lawyers could be somebody who's been advising your family for decades, and it may be perfectly all right leaving him $1 million. But it does raise red flags, right? As to, was the person competent when they wrote this will, or did the lawyer take advantage of them? Right? If this was, for example, if you wrote this when you were in your 30s or 40s, and after that you had a productive life, it's going to be much less suspicious if you wrote it when you're 95 and you were already in a nursing home, right? So things like that can be contested, basically making sure that people are in their right mind, especially when there's something weird about the will. Like you're leaving not just to your kids or spouse or like relatives, you start leaving things to some young person that you may have met like online, like 3 months ago or whatever, that people will start asking questions about.
Okay, we have an audience member who's asked a question.
Okay.
What's the price point for cost to be expected to pay for this service?
To set up a trust, I think setting up a trust shouldn't be that expensive. You can really do it. Probably there are now like online programs. Is the question, is it worth having it to find somebody to administrate it, etc.?
Can you recommend some sources where one can receive guidance for wills?
I think if you want true guidance, you probably should consult an attorney. And generally, they're not that expensive. Now, obviously, the more complex your estate gets, and the more complex of a gift you want to leave, the more expensive it will be. But a fairly simple will is going to cost you a couple $100. It just should not be that expensive. So that will be the guidance. And usually what will happen, so that's what my parents did. I found them an attorney, and they have a will. It's not a very complex one. Probably needs to update it because, for example, it lists their house, which they sold and moved to Israel. But yeah, we met with this attorney. The attorney spent about maybe like an hour with us talking about like, well, what do you have? What are your goals? Like, who do you want to take care of? Do you want to take care of your kids equally? Like, do you have any specific things that you want to say like, oh, this goes to that person, this goes to that person? They'll also ask like, well, who do you want to administer the will, right? Basically, because somebody needs to actually distribute that property. And so after attorney sort of spends it like that 45 minutes, an hour with you, if you have a fairly simple estate, they'll draft a document and that's it. As it gets more complex, it will cost you more. But I wouldn't recommend just go read a book because it can get very complicated very quickly. So consult a lawyer, a real lawyer. We've been talking about here kind of general rules, but New York may have very different rules from New Jersey, which may have different rules from Connecticut, which may have different rules from Virginia. So you should consult a lawyer depending on where your property is. And for example, if it gets complicated, for example, if you have an apartment in New York, but you have a beach house in Florida, right, or some condo in Florida, you may have different rules as to how those get disposed of. So you may want to consult somebody who knows that.
Okay, thank you. So before someone even meets with an attorney, what is helpful for them to think through or prepare?
Well, first, it's certainly helpful. You don't need to do to the last cent, but it's certainly helpful to take stock, pun unintended, take stock of what is it you own? And generally think about like, what do you want to happen after that? Like maybe you don't want your kids to have any of this money, right? Maybe you don't like your kids, or maybe you think your kids are already set up fine, doing fine on their own. And what you want to donate money to an animal shelter or whatever. So kind of have at least some general idea what you want to happen with your stuff. Okay. Have some general idea who do you trust to administer it. So because the lawyer will simply write the document, but again, somebody will have to say, they'll have to come to your house and like clean it out and say, okay, you get this and you get that, and like and go to a bank and say, okay, well, here's a death certificate and this money goes there, right? Someone will have to do that, dirty work. So think about who you trust to do that. And maybe talk to whoever it is that you plan to leave stuff to. Like talk to your kids or your spouse or your again, whoever is like is on your list and see if they if they want it, if they want to be part of this. And kind of like those fairly basic things. You don't necessarily need to come to an attorney saying like, well, I definitely want to trust and I definitely want this and I definitely like you don't need to know the details, but you kind of what's good is to know like what do you have? What do you generally want to happen to that stuff? And what do you generally maybe don't want to happen to that stuff? Right? Kind of like what are your red lines? And then the whole point of a lawyer is to kind of to take your wants and desires and put into legal and enforceable legal language.
Okay, so in the wills, how detailed can they get?
Oh, they can run thousands of pages, right? Again, depending on what is it that you have. If you have lots of different properties, you have lots of interests that you want to benefit. It doesn't have to be just a family. Like I said, you can leave money to universities, orchestras, animal shelters. You can set up scholarships. You can do, I mean, whatever. You can do whatever. It's your property. It's your money. It's your
Got it.
estate.
It's your tchotchkes.
Right, exactly. It's your tchotchkes, and you can do it at whatever that you want. And so, the more complicated your desires are, the more complicated the will is. There's also kind of situations where you want to say, well, what happens if my things don't come to pass? So, for example, you say, look, I want to leave money to my, I don't know, let's say, not to get too morbid, I want to leave money to my child. Okay. But what happens if the child actually dies together with you? Like, what happens then? So you may want to basically have contingency planning, saying, okay, to my child, but if not to him, then to, my favorite university. But only if they're willing to set up a program that studies, I don't know, Jewish life in Japan before like 1600s or whatever. But if they're not willing to set this up, then to some other, right? So you may have multiple contingencies as well. You can do the same thing in a trust as well, right? You can say, look, this is for the benefit of my child unless they sort of say die before they're 21, in which case for this. But in a will, you can have like, look, I leave this money to X unless something happens, in which case to Y, unless something happens, in which case to Z, et cetera, et cetera. And as you obviously have more and more contingencies, the longer and longer your will gets, right? It can be fairly simple. It can be just 2, 3 pages if you don't have very complicated planning. And you just want to say, look, whatever I have, divide it like 3 ways between like these 3 people, done. But it can be, if you have lots of different properties, and especially the more stuff you have, the more you have to start thinking about also taxation issues. And so you want to set up in different ways to minimize the tax obligations. So it can start running into dozens and hundreds of pages.
In this case specifically that you just stated, okay?
Mhm.
How would that be different with a will and a trust? It sounds like the same thing to me right now.
No, because again, so will is you just leave the principal
After,
right,
oh, okay,
after
got
you
it.
die.
So it's all
The
about the
trust, you can
principle.
also be after you die, but you don't leave the principal. You basically you
Got it.
say the principal gets administered by a manager for the benefit of a person that I choose to be the beneficiary.
Got it. Okay.
No, but you can of course say if the beneficiary dies, if the beneficiary say your favorite orchestra, if the beneficiary dissolves, they no longer exist, then maybe to some other beneficiaries. Or you can say if the beneficiary no longer exists, then take the principal, right? Because there's nobody to benefit, and then distribute it in a particular way. So there can be a whole bunch of contingencies.
Right, right, right.
There are also various rules. So imagine you set up a trust to said like, look, 100 years ago, set up a trust saying, I want this money to benefit the curing and treatment of polio. I have left a whole bunch of money. Now, fast forward to 2025, there's basically no more polio, right? Or smallpox or whatever, right? That used to be a big deal, and you thought like it would be a good idea to leave your wealth to fight the disease. And now there's, well, we won that battle. What do we do with the money? So courts might get involved in saying, okay, what's the closest thing to what this person who set up a trust wanted? And the closest thing could be, okay, well, we're no longer fighting polio, but closest thing would be like, let's say AIDS. And so we can basically, the trust can use the money to fight a similar disease. Or the court can say, well, no, the trust basically achieved its purpose. And so the principal has to be basically distributed in a particular way. One of the advantages of trusts is that there is this judicial supervision, right? So a trustee can't act in his own self-interest, and trustee can't decide like, oh, well, this thing is stupid. I don't want to do that anymore. I'm going to like do something else now. Trustee has to carry out desires of the person who set up the trust. And if they want to deviate from those desires, they have to go to the court. And if they do deviate from those desires without going to the court, they can be sued and be forced to repay the money that they've misspent. So there's this kind of backstop for trust that that there are judges basically looking over this, making sure that your desires are actually carried out.
So, what mistakes do you see people make when it comes to making those decisions or not making those decisions?
I think the biggest mistakes is basically not making decisions, right? Saying, well, or thinking, I'll do it eventually, because unfortunately, none of us know when our time comes, and like eventually may never come, right? So I think that's the biggest mistake. That's actually a good point to mention, that sometimes if, for example, all you have really is, say, a life insurance policy, you may not necessarily need a will, because the life insurance itself asks you, well, who's going to be the beneficiary after you die? And even if you do have a will, once you name a beneficiary on your life insurance policy, it doesn't go by will, it goes by that policy. But, I have some stuff here, like, you can see behind me, I have some books and whatever, if anybody wants them, but I have not written anything. So everybody who's listening to this program should do as I say and not as I do. So I think the biggest mistake is not making those decisions, not writing anything down. The other mistakes and this is going to sound fairly silly, is that like people, it's kind of like it's a smaller version of not writing anything down. It's the smaller version is not writing everything down. So like if you say like, look, I'm going to divide X, Y, and Z and forget to mention your old records collection. Now, maybe nobody wants it and people will just throw it out, but maybe somebody will want it and maybe two people will want it. They're going to fight over it. So one big mistake is not sort of thinking through what is it that you have and mention it in a document, especially things that are not easily divisible or replaceable. Related to that, I imagine like people not talking to those that they want to benefit, right? Whether it's their spouse or kids. So if you have that record collection, maybe you should ask your family, like, does anybody actually want it after I die? Because if not, like if you do, then I'll put it in like in the document. If two people want it, then maybe I'll find a way to split it up or something like that. So, talk to your intended beneficiaries.
I'm going to start doing that.
Right.
Who
So,
wants my pots and pans?
exactly, pots and
I'll
pans are
start
like,
doing that now. Yeah.
no, I mean, one thing that when my siblings want to drive my parents insane, when we're kind of really just want to poke them with a sharp stick, when we gather for dinner at their house, we just start saying, well, I get this and I get that. And my mom just like, dude, we're still alive. I'm like, I know, but we're just telling you right now who's getting what. And then there's something that nobody wants. And so the person who showed up last dinner is like, okay, you're getting that one because nobody else wants it. Like that's a punishment. So sometimes it can be done very amicably and everybody knows what everybody wants and and it can be divided. Like, for example, in my family, there are some dishes that actually belong to my great grandmother, after whom my sister is named. And so everybody knows that that's hers. Like when time comes, those dishes that like travel out from Soviet Union, etc., those are her, and nobody, even if I wanted them, like I have no claim to them. Conversely, there's some things that are for the same reason are mine. And so sometimes it can be done very amicably, etc., but not always. And so just it pays to write those things down. And so I think those are the biggest mistakes when people don't sort of think through, especially things that may actually have no value. Right. I don't know, like with those dishes that my great grandmother bought, like have any, probably not, like. I think they're Chinese made, like China, not like from like 18th or 19th century, just like whatever. We bought in Soviet Union. So probably have no market value, but they have like family value. And so when you have those things, it might make sense to sort of talk things through and kind of and think about like who do you want to leave them to.
Speaking of writing it down, does it have to be a will? Can it be written on a piece of napkin? Or does it have to be in front of an attorney notarized?
Yes and yes.
Okay.
So you could write things down. Generally speaking, if you write it down, at least traditionally, you actually literally had to write it down in your own handwriting. Because that way people can say, okay, well, I recognize that handwriting. I know like nowadays, I don't know if anybody can recognize anybody's handwriting because nobody writes anything anymore. But like those types of documents generally are acceptable and can be written on a napkin, etc.
No kidding.
Yes, they could. In fact, for example, when I was studying for the bar, there was a kind of both a hypothetical but a true story. Like early in, I think, in 20th century, a miner was caught in a mine, like in a mine collapse, and as with his basically dying kind of breath, literally scrawled on the rock where he lay dying, like something. I leave everything to like my wife, and that was enough. So it's not a question of like formality. It's a question of like trying to basically can the courts that will then probate your will, can they actually have sufficient confidence that that's what you wanted, right? And so I kind of said, like, look, if a person had enough strength to, as he lay dying, know that certain death is about impeding, he could scrawl on a rock saying, I leave everything to, so like, we're pretty confident that's what he wanted. So yes, it could be written on a napkin, but obviously, especially if you're not an attorney, you may not think through all the complexities. Again, if you don't have much to leave and if you kind of just that's fine. But if you want to take advantage of certain tax treatment, if you want to think through the eventuality. So, for example, my parents wrote a will. Again, and their will is very basic, but they had like an eventuality. So my mom left everything to my dad, and my dad left everything to my mom. But the eventuality of like if that doesn't happen, then to the kids. And people may not necessarily, without legal training, may not necessarily think through that. So can you do it on a napkin? Yes. But usually we want wills to be, it's not so much notarized, we want them to be witnessed. So usually you have two witnesses who say like, yes, I saw this person sign this document. I know that they were in the right mind. They don't have to say, I approve of his choices, but they say, I saw the signature. I verified the signature. I know the person's in the right mind. I know this person. And so it's kind of safer. But now you can scroll it on a wall.
Okay.
Actual case in Virginia.
Is there
By the way,
any?
one point is like, you can't set up trust that way. Right?
You can't.
Trust is a legal document because you have to pick a trustee. You have to set up specific purposes, like what this trust is going to do. You have to decide what assets are going into the trust. It's kind of like setting up a corporation. You can't set up a corporation on a piece of napkin. You have to register it like with the state. You have to do all of those things. Will, you can do, like I said, you can scroll on a napkin. Trust is a much more formal process.
That's good. That's a big difference. That and the principle.
Right.
Okay. Is there anything else you'd like to leave our viewers with? This has been such an incredible conversation. It's finally a little bit clear for me. I'm less intimidated. So wills and trusts is like no big deal. I've had a few of my audience members ask me to do this program because it is quite a topic, but it sounds like it's very, very straightforward and nothing to be afraid of.
No, I think that's exactly right. Again, obviously, if your finances become complicated, and that's, by the way, it's a good thing. If finance is sufficiently complicated, it means you probably have enough assets for them to be complex. So that's a good thing. But as your finances become more complex, so does the kind of the estate planning. As your finances become more complex, it means you have more money. It means you can afford to pay for attorneys to deal with those complexities. But for simple things, it is not that complex. It can cost you just a few $100s, like under $1,000, to write out a will. And by the way, it's not that expensive to change it either. So for example, you set up a will now and you said like, look, I'm going to leave everything to so and so, and then they decide to get married or they decide to get divorced or they have kids that they didn't have at the time. You can change it, right? So will is not effective up until you actually die. Up until then, it's basically just sits in a drawer, waits its turn. And if you decide like this no longer reflects your wishes because whatever you wished for when you were 30 is not the same thing that you're wishing for when you're 50, write a new will. Okay, it's going to cost you another couple $100. Or like if you acquire, or even if like you have the same desires, but you acquired new property and you're like, okay, well now I have to think about that. You can add what's called a codicil. Basically, it's an addendum to the will. So it's not a complex process, especially if you have a fairly simple estate. It is a process that people don't like talking about because it involves indirectly talking about death, and nobody likes talking about that. But I guess what I would leave your listeners where I started. and that will make it easier for them. So think about it as like making life easier for people that you love and for causes that you cherish.
It's very considerate way
Oh,
to go.
right. Exactly.
Not to get morbid.
Exactly.
Okay, it's all about, making decisions while you still can,
Exactly.
so that other people don't have to guess later, or when you're, God forbid, you're not able to make those decisions, you won't be put in that position.
Exactly. Right. Exactly.
Thank you so much for breaking this down in a way that actually makes sense. I hope it made sense for everyone listening. If you haven't yet, please subscribe to this channel, like, share, and leave a comment. We'd love to hear what you thought. Mr. Greg Dolin is available to comment on the comments you'll be posting.
Yeah.
I hope.
Happy to.
Fantastic. And that's it for today. We hope to see you again, maybe
I
we'll
would love
find.
to. I would love it.
Thank you so much.
Bye. I'll see you soon.